First to arrive at the East African Court of Justice was Senior Attorney Elisha Bafirawala and his colleague Gerard Batanda. The two lawyers are representing the state in a case Democratic parties sued not only Uganda, but also Rwanda, Burundi, and Kenya. Democratic Party is displeased by failure of all four countries to deposit a declaration that would in a sense allow citizens and NGOs within their borders to access the African court when their rights are violated. Democratic Party's lawyer Mukasa Mbidde contends that ratifying the treaty means that all East African community countries subscribe to the protocol to the African Charter on Human and People's Rights.
And I would like this court to declare that this is an infringement of the East African Community Treaty for these partner states. The court is established, we have had judges, but the court is idle, and the people have grievances, but they have no access to the court.
It is the function of the president to enter into international treaties and international agreements. So it cannot be the function of the court, for instance, this East African Court of Justice, to compel the president to enter into an international treaty.
The Democratic Party in 2012 also sued the East African Community Secretary General for failing to advise partner states on their treaty obligations. The party argues that the sovereignty of the four states was taken away when they subscribed to being part of the East African community.
If the Republic of Kenya does not wish Your Lordship to deposit in respect of its citizens, then Your Lordships, the Republic of Kenya is free to do so.
When you ratified, you said, I agree to that court. Then you say, I'm not depositing it, and you take 10 years. We're asking this court to examine the fact that that is unreasonable.
With various human rights violations recorded in various member states, the delay would tantamount to justice denied. This Mbidde adds contravenes the African Charter, which not only fosters good governance, but also upholds human rights.
A case in point is the Public Order Management Bill that has been passed by Uganda. We have got communities that are aggrieved, where there are areas there is rampant extraction of oil, but the revenues are not trickling down to the communities. Such communities have their rights infringed upon. We have areas like Buganda, whose federal status that had been that was unceremoniously removed by Europeans is the clamor that they still have.
On the 22nd of January this year, Rwanda deposited its declaration, but it had already been sued. And although the applicants have withdrawn the case against it, they say this should be subjected to costs.
We're saying that argument is misconstrued and not valid. It has no truth in it.
Judgment shall be given notice.
Sudil Biarhanga, NTV, Arusha, Tanzania.